Yo, what's up YouTube? It's BPcast back again with another video and another reaction. And in today's video is day 2 of the state of Florida versus Calvin Riley. The incident that I was covering for the past few days. This is the end of the trial, so I'm gonna watch it, get my reaction. Let me know what y'all think about it and what y'all think about the verdict. I'm gonna be also skipping through, but I will be like showing y'all the pinpoints, and let's get into the video.
Officer Muth, is your testimony here today that you did not use the vodka bottle as evidence?
Are you asking if I used it as evidence to arrest him?
I am asking you if you used it as evidence.
It was discovery after he was already placed under arrest.
Officer Muth, you testified previously at a pretrial hearing.
She's got to get her information out. Overruled at this time.
You testified previously at a pretrial hearing.
Yes.
You were under oath at that hearing.
Yes.
You swore to tell the truth.
Yes.
There you were asked in counsel in court. It's page 40, lines 27 through 28, continuing on to page 41, lines 1 through 3. Question. And in that report, you mentioned that a vodka bottle was found in a pouch on the driver's seat. Is that correct? Answer. Correct. Question. And you mentioned that because it was evidence. Answer. Yes. That's inconsistent with your testimony today.
Okay. You asked me about the vodka bottle, and I thought you meant it played into his evidence in his arrest at the point the vodka bottle was found.
But you had automatically assumed that that vodka bottle was what was used and put in that cup.
Yes, which was a mistake on my end.
And you thought that even though the bottle was sealed and had never been opened.
I never examined it.
And again, you confirmed that he's only under arrest for driving while license suspended.
That's what I told him. I thought he would infer that he was also under arrest for DUI because he had just refused the field sobriety exercises.
At that point, you were only charging him with driving while license suspended.
No, he was placed under arrest for DWLSR and DUI.
That's your testimony here today.
Yes.
You had a body-worn camera on.
Objection, asked and answered.
Sustained. We've been through this.
No, Your Honor, it's a different point in time.
Okay, go for it. Overruled.
Your Honor, can we just briefly move sidebar?
Not yet. Let her finish her questions to see if there's another
Your Honor,
objection.
the state was just curious as to whether or not this is the one that was entered into evidence or if it was the other one.
Yeah, but if you could use the video from Exhibit 4. Okay.
Man, one thing about court, bro, it'd be so damn boring, man. I swear I would fall asleep. Not even lying. I'll just skip through this.
At that point, you were only charging him with driving while license suspended.
No, he was under arrest for DUI and DWLSR.
That was not my question. At that time, you were only charging him.
Asked and answered.
Sustained, she just said he was under arrest for DUI and DWSR.
Those are not the same thing, Your Honor.
Let's go sidebar so you can explain it to me.
You go back to speak with Mr. Riley.
Yes.
He's upset that you claim to smell marijuana.
I never smelled marijuana, Officer Oliver did.
He's upset that Officer Oliver said that she smelled marijuana,
Yes.
but you never smelled marijuana.
Correct.
You never found any evidence of marijuana.
Correct.
You described
Bro, I swear they both said they smelled marijuana. Like they both were saying it. And I don't know, bro. I swear they just use marijuana as excuses to search the car. Because I swear she said it too.
him as extremely irate and belligerent.
Yes.
You indicate in your report that he attempted to exit your car.
While I was reading implied consent, yes.
He never moves his feet.
He leaned forward towards me.
He leans into your body-worn camera.
He leans his body towards my body. I don't know what he's going to do.
He wasn't trying to escape.
I can't speak to that.
Again, at this point, you have only told him that he is under arrest for driving while license suspended. And then Sergeant Smith comes on the scene. There's a point where you're discussing what to do with his car.
Yes.
Officer Oliver suggests moving it to the parking lot,
Yes.
but you disagree.
Yes, I said we should tow it.
And you want to tow it because, to you, he'd done nothing to meet you all in the middle.
Yes, that's what I said.
Now I wanted to say something on that. I feel like that's just a whole ass thing to do, bro. Like the fact that they could have just like put that on the side, but since he ain't working with us, we're just gonna make him cost more money. You see what I'm saying? It's like that's just like being like so like as an officer you do deal with a lot of things. You do deal with a lot of like BS people, but you shouldn't like make their life harder by let's tow it so he pay this and all this. You know what I'm saying? Just because he ain't agreeing with y'all, like I don't know. But at that point, y'all just call a supervisor.
When Sergeant Smith is there, you discuss the search.
Yes.
And when he first asks you if there's anything in there, you indicate no.
I thought he had meant the marijuana.
Then you say, well, okay, so he had a bunch of alcohol stashed in there.
Yes.
He specifically asks you nothing open or anything.
Yes.
And you say, yes, it was opened.
Yes.
That there was a mixed drink in the center console.
Yes.
You're explaining to Sergeant Smith that he was mad, as in Mr. Riley was mad, that Officer Oliver smelt marijuana.
Yes.
That is why you searched the car.
We searched the car for her plain smell of marijuana and then the search for the DUI.
Sergeant Smith asks if you're still live.
I can't speak to what Sergeant Smith said. I believe he said he was still alive.
And that means that your body camera is still on.
Yes.
Specifically, he asks you, did you find any evidence of marijuana?
Yes.
And you say no.
Yes.
And this is when Officer Oliver walks up.
Yes.
She asks you if you got all the same indicators she did.
Yes.
You are still discussing this arrest.
Yes.
You are still discussing this case.
Yes.
You are still investigating.
We're discussing.
And then you turn off your body-worn camera.
Yes.
But first you ask her if she still got her body-worn camera on.
Yes.
And she shakes her head no.
I believe she did.
And then yours cuts off and your next body-worn camera turns back on 3 minutes later.
Yes.
There are 3 minutes at this exact same time where you all have your body-worn cameras off.
Yes.
The first time you tell him he's going to jail for DUI is when he's already in the car on his way to jail.
Yes.
And that's after you've searched the car.
Yes.
A moment to confer, Your Honor.
Yes.
Nothing further, Your Honor.
Any redirect?
Briefly, Your Honor. Officer, I want to start from the beginning of where Ms. Goodfellow asked you questions about. Why were you called to the scene?
To investigate a DUI.
Okay. Was that because you were helping Officer Oliver?
So she had been on the squad for a little bit and she wanted to learn how to do DUIs, so.
And that's another point that I wanted to point out. This Officer Oliver, the one that poured out the liquor bottle, she never really did DUIs because she was like still new. And so she was like wanted to, like, I guess, show her how to do DUI or whatever, you know, to search for alcohol. And that's another thing that bothers me, you know, that she's new, but she poured it out and then claimed that it was open. So how many other people has she did that to before, you know? Like, despite with this situation, because they're going to, I know for a fact they're going to go off and say, well, you know, he left the bar and all this and that, but it's just the fact that she poured out the liquor bottle and said it was open. Like, who else she probably did that to and, like, they got wrongfully arrested, but that's just my thing on that.
I was helping teach her.
So we talked about, or Ms. Goodfellow talked about a Signal 1 investigation. Can you tell the jury a little bit about what a Signal 1 investigation is?
Signal 1 is just our code for DUI investigation.
So does a Signal 1 or DUI investigation, does that start from the moment you make contact with the individual?
Yes.
Does it extend all the way until the very end of the investigation?
Yes.
So when you were conducting a search of the vehicle, were you still in a Signal 1 investigation?
Yes.
What about when you were reading implied consent?
Yes.
Okay. What about when you asked the defendant to do field sobriety exercises?
Yes.
Now, we also talked about field sobriety exercise. I believe Ms. Goodfellow actually brought up the fact that there was field sobriety exercises request. Can you tell the jury what the defendant did when he was asked to do field sobriety exercises?
Your objection is sustained. Move on.
Defense counsel also asked you about how Officer Oliver said she knew that the defendant knew he had a driver's license suspension. Did Officer Oliver tell you about the notices that were sent to his P.O. box?
I believe she said they were sent to the Brevard Street address box.
But did she tell you that there was notices sent?
Yes.
Can you explain to the jury what notices like when notices are sent, what that means for an investigation for somebody who's driving with a suspended license?
They sent.
Objection, calls for hearsay in Crawford.
Overruled.
I'll ask the question again. Can you just tell the jury a little bit about when notices are sent to an individual from the DHSMB?
Objection, beyond the scope.
Overruled.
Officer, can you please tell the jury when notices are sent to an individual and DHSMB tells you about that in the internal system, what does that mean for your investigation for somebody who's driving with a suspended license?
DHSMV will send the suspension notice to their primary residence, and in this case, they sent the suspension notice to his primary residence, and it updates in our system with the address that the notice would have been sent to.
Your permission to publish State's Exhibit 1, what's already been entered?
Yes.
Officer, let me know when you can see it.
Okay, I can see it.
Now, I'm directing your attention to right here where it says, right up here in the corner. Can you tell us where this document's from?
It looks like the Florida DHSMV.
Now I'm directing your attention to the subheader that says mailing address. Can you tell the members of the jury the mailing address for the defendant?
You want me to read the address?
Yes, please.
P.O. Box 11184, Tallahassee, Florida 32302.
Officer, if that was the address listed if that was the defendant's mailing address listed with the DHSMV, would that have been where his notices were sent?
Objection beyond scope.
Sustained.
Now I want to transition over into another section of questioning that the defense asked you about. When you placed the defendant under arrest for DUI, did you believe you had probable cause to arrest him for DUI?
Yes.
Did you believe you had probable cause to arrest him for driving with a suspended license?
Yes.
Let's take those one by one. When you arrested him for DUI, can you tell the jury why you believed you had probable cause at that point?
Objection, Your Honor. Cumulative.
Overruled.
Can you tell the jury why you believed you had probable cause to arrest him for DUI at that point?
Based on the totality of the circumstances, Officer Oliver had observed poor driving patterns, and then my own personal observations with the thick, slurred speech, watery, bloodshot eyes. He had said he was leaving a bar and said that he had consumed a couple of 2 beers there.
Now I want to transition into the second charge. Can you tell the jury why you believed you had probable cause for the driving with a suspended license?
The suspension notice had been sent to his primary residence.
Officer, after you placed the defendant under arrest, did you also search his vehicle?
Yes.
Okay. So can you explain to the jury, when you search somebody's vehicle, or are you allowed to search somebody's vehicle automatically when you place them under arrest?
No, there has to be, it depends on what they're under arrest for, and there has to be certain things.
Typically in DUI investigations, are you able to?
Yes.
Okay. When you decided to search the vehicle, did it have anything to do with the smell of marijuana?
We could search on Officer Oliver's observation of the plain smell of marijuana, and but we could also search for the DUI.
I really feel like she doesn't want to say that, yeah, we searched her car basically because she smelled marijuana. Like, just say that. That's what y'all searched the car for. That's clear as day. But they don't want to lose their job.
In DUI investigations, actually strike that. I want to be clear, was marijuana what you suspected the defendant to be under the influence of?
No.
Can you tell the jury what you suspected him to be under the influence of?
Alcohol.
Was alcohol your primary concern throughout your investigation?
Yes.
Now I want to transition also to the breath test that you asked from the defendant. Opposing counsel asked you a bit about how the defendant was leaning towards you. Can you describe to the jury what it was like when he was leaning towards you as you read the implied consent form?
Objection, relevance.
Overruled.
Can you tell the jury what it was like as he leaned towards you when you read the implied consent form?
Sure. So I was just trying to read the implied consent form. Like I said, it was one of those procedural things for a DUI, and he was yelling at me the whole time, and then when he was leaning towards me, I didn't know what his intentions were. So that's why I shut the door, and then I continued reading implied consent through the open window. I thought he might, if I had kept the door open, I thought he might try to exit the vehicle or try to, I guess,
Objection calls for speculation.
Sustained.
Officer, can you just give us a visual estimate with your hands about how far away he got to you, or how close he was to you when he leaned towards you?
I I would say probably that close.
No further questions.
Does this witness need to be retained?
Yes, Your Honor.
All right, you can step down, but please do not leave the courthouse.
Thank you. I still have the paperwork that,
And then that was like that was Officer Mule. That was the other officer that was there that they was interviewing. And then the next person was the superintendent, and he pulled up I think like 20 minutes or so after they stopped him. And so this is them interviewing him about the incident. Not interviewing, but in court.
Could you please introduce yourself to the members of our jury?
Yes, my name is Brian Smith. I'm a sergeant with the City of Tallahassee Police Department.
And for the record purposes, can you spell your last name?
Yes, it's S-M-I-T-H.
Sergeant Smith, I want to talk about your experience as an officer for starters.
Yes, ma'am.
Could you tell us, I know you said you work for the Tallahassee Police Department. When did you start working for them?
In December of 2008.
Okay. So for a total of how many years at this point?
It's 15.
So during the 15 years at Tallahassee Police Department, did you receive any training related to DUI investigations?
I did not specifically, no, ma'am.
Okay. Have you ever responded to DUI investigations?
Yes, ma'am.
Are you usually backup, or can you give us a little insight into what your involvement usually is?
Typically, it's as a backup officer, so it would just be for, while the officer is conducting their investigation, I would just be there for safety purposes, or to assist with traffic control, just depending on the situation.
Okay. So I want to transition over to this case.
Yes, ma'am.
Do you recall if you were on duty the early hours of May 7th, 2023?
Yes, I was.
Were you called to a scene of a traffic stop around 2 a.m.?
Yes, ma'am, I was.
Can you tell us what your understanding of your involvement was that morning?
Initially, they just asked for me to respond. When I got there, I was informed that Mr. Riley had been combative, and they just needed assistance getting him from Officer Oliver's vehicle to Officer Mule's vehicle.
Do you recall what time you arrived at?
It was right around 2:25, 2:26-ish in the morning.
So when you arrived at the scene, did you end up speaking with the defendant at all?
Yes, ma'am, I did.
Did you have your body-worn camera footage on?
Yes, ma'am, I did.
If I showed you a copy of that, would you recognize it?
Yes, ma'am.
Permission to approach?
Yes.
Let the record reflect I'm showing opposing counsel was been pre-marked as State's Exhibit G. And I am now approaching the witness for the second.
CD.
Handed you what's pre-marked as State's. Sergeant, I've just handed you what's pre-marked as State's Exhibit G. Can you tell us what that is?
It's a CD
And-
with my signature on it.
What's on this CD, to your knowledge?
It's actually my body-worn camera from the night of the incident.
Did you have an opportunity to review that before today?
Yes, ma'am, I did.
Were you able to confirm if this was a fair and accurate copy of your body camera?
Yes, ma'am, it is.
Has it been changed or altered in any way since you last seen it?
No, ma'am.
The state moves into evidence what's been pre-marked as State's Exhibit G as State's Exhibit 6.
Any objection?
We would object and ask to approach on one brief testimony.
And it'd be so long pauses in court, bro. I would fall asleep.
Sorry, ladies and gentlemen, we need to take another break. This is going to be a very short one. I just need to listen to something and rule on it outside of your presence.
Oh, so they're taking a break.
With officer move.
Right here.
Continue.
The defense is okay with that? I'm okay.
We're okay to just mute it.
The state won it,
Relating to the breath test that you were asking about?
Sure.
Right here.
Explain to the jury
This is what I
defendant
want to talk about right here.
breath test.
Yes, ma'am, I did.
Could you just explain to the jury what your interaction was relating to the breath test that you were asking about?
Sure. Mr. Riley was upset about the whole situation, so I just explained to him that he'd be afforded the opportunity to provide a breath sample if all this was a misunderstanding.
So when you say to the defendant, if this is all just a misunderstanding, to take a breath test, can you tell the jury how he reacts and responds?
From my interpretation, he was not interested in that avenue.
Would you classify it as a refusal?
It wasn't explicitly stated, but in my opinion, he was refusing.
No further questions.
Cross-examination?
Yes, Judge. Good morning.
Good morning.
So you showed up after the fact,
Yes, sir.
kind of there to keep everything level headed.
And if I'm correct, I think this is Calvin's attorney or one of them.
Yes, sir, to move him from one vehicle to the other.
And so by the time you showed up, he had already been arrested.
Yes, sir, he had.
And he was in Officer Oliver's car when you arrived.
Yes, sir, he was.
And then he was subsequently transferred to Officer Muth's car.
Correct, yes, sir.
He was cooperative when you transferred him.
Yes, sir.
He was able to walk on his own to the car.
Yes, sir.
Didn't trip.
I don't
Objection
recall.
outside the scope.
Overruled.
He didn't fall.
No, sir, he did not.
He didn't stumble.
No, sir.
He was able to get in the vehicle with no issues.
Yes, sir.
You helped Mr. Riley make a call after that point
Yes, sir, I did.
while he was in the vehicle.
Yes, sir.
Objection outside the scope.
Overruled.
He was able to call someone and explain what was happening.
Yes, sir.
And he was cooperative while you were helping him do that.
Yes, sir, he was.
His hands were cuffed behind his back.
Yes, sir.
He's seated.
Yes, sir, he's seated.
He maneuvers his handcuffs kind of over to the side,
Yes, sir.
opens his phone,
Yes, sir.
and types the numbers,
Correct, yes,
calls
sir.
his family. And he was cooperative with you up until Officer Muth and Officer Oliver returned.
Yes, sir, he was.
Okay. And after that point, he declined any further communication.
Correct, he did not want to speak.
Okay. He stated several times he was not talking to you guys.
Yes, sir.
And after ending the conversation with Mr. Riley, you spoke with Officer Muth about the search of Mr. Riley's car.
Yes, sir, I did.
You asked her if she found anything.
Yes, sir.
She says she had a bunch of alcohol stashed in there.
Objection outside the scope.
Overruled.
Yes, sir.
So, she did say she had a bunch of alcohol stashed in there, correct?
Yes, sir, she did.
And you, when you're the supervising officer, take the officer's word on that.
Yes, sir.
You didn't do any, you didn't check for yourself to see if it was open or half poured out or anything like that.
I did not check, sir, no, sir.
You kind of rely on them being truthful with you.
Yes, sir.
And then you guys ended up discussing with Officer Oliver the evidence that you believe supported a DUI charge.
They may have gone over some things, yes, sir. I don't recall exactly what the specifics were.
And during that discussion where you discussed charges, all three of you had your body camera off, is that correct?
Honestly, I'm not sure what we discussed after the camera was turned off.
Okay. Can't remember that part?
Sir?
You can't remember that part?
Correct.
Okay. You didn't write any reports in this case?
I did not.
Okay.
I mean, that's kind of odd, like to turn off the body cam footage and not remember like what y'all was talking about. I don't know, that's just really odd to me. And that I feel like turn off body cam footage should be like low key illegal. I don't know if they like if different police agencies or whatever have different rules on that, but me personally, I feel like they should never turn it off. Like it should just stay on and never be turned off until you gotta take that uniform off. Like when you put the uniform on, it's on, and when you take the uniform off, it's off. I feel like that's better than for them to be able to have the option to turn it on and off. That's just my opinion, though.
No further questions.
Any redirect?
No redirect, Your Honor.
All right, let me step down. Does it need to be retained?
No, Your Honor.
Free to go. Thank you, sir.
Thank you.
I'm sorry. I know the defense had or the defense.
All right, does the state wish to have him retained?
The defense wishes to have him retained.
Okay, so if you're still under subpoena from the defense, don't leave the courthouse.
Competent substantial evidence as to element 3. Florida statute 322.34.
And this is Calvin's attorney right here. Well, one of them,
subsection
the lady.
2 provides how the knowledge element may be satisfied. It reads, the element of knowledge is satisfied if the person has been previously cited as provided in subsection 1, or the person admits to knowledge of the cancellation, suspension, or revocation, or suspension or revocation equivalent status, or the person received notice as provided in subsection 4. There shall be a rebuttable presumption that the knowledge requirement is satisfied if a judgment or order as provided in subsection 4 appears in the department's records for any case except for one involving a suspension by the department for failure to pay a traffic fine or for financial responsibility violation. Additionally, 322.34 subsection 3 does provide that in a proceeding regarding a violation of the section, that the court may consider evidence other than those specified in subsection 2 that the person knowingly violated the section. The state has presented a certified driving record which shows Mr. Riley's driver's license was suspended on May 7, 2023. The record provides the basis for the suspension as personal injury protection, property damage liability, commonly just simplified and abbreviated as PIP. PIP is a financial responsibility violation, which was suspended pursuant 324.0221 within the chapter titled Financial Responsibility. Because Mr. Riley's license was suspended for a financial responsibility violation, there is no presumption of knowledge based on department records indicating a notice was sent. Mr. Riley never admitted to knowing his license was suspended. Rather, he told officers that he did not know. And the state did not present any evidence that he had previously been cited under 322.34. Therefore, the knowledge element is restricted to 322.34 subsection 3, which allows the court to consider other evidence. In this case, the state has presented testimony from Officer Oliver that the notice was sent to P.O. Box. However, she also admitted that she previously testified under oath that the notices were sent to 429 West Brevard. Those are exactly contradictory, Your Honor. They did not present any evidence in the matter from anyone who actually knows where the notices were sent. Further, the state has presented a current driving record. The record does not represent his driving record at the time, noted by the inclusion of suspensions in September 2023. Which was after this incident. Also, the driving record provided includes two addresses, a residential address and a mailing address, which are different. I'd like to present the court with two cases, Your Honor.
Okay.
May I approach?
Mr. May?
I have copies for the state.
And basically, they're talking about, his license because he didn't know that it was suspended. And they're trying to, basically, when they were talking about like the mailing and all that, they're trying to say that they mailed it to the wrong address or something like that for him to get a notice that his license was suspended. So that's basically what they're going over right now. And
All of this is saying that it went somewhere else. They have not presented any evidence, but anyone who actually knows where these documents went, if they went anywhere.
so that's basically their argument on that. And then after that, they went on like on a long lunch, like if y'all want to see this, I'll put the link in the description. Y'all want to see like the entire case, but this thing is like, I think this whole, it was like 6 hours long. Yeah, it was 6 hours long. I'm trying to cut this into like not an hour, but like 40 minutes. But then they come back from lunch and they took a lot of breaks. So I'm gonna play where the defense and then the state had their closing arguments on everything, and then I'll play like the verdict and everything like that.
Not influence the term.
Then we'll go
Your
over
verdict must be based on verdict that is necessary.
Defense.
So this is the state right here. This is the state.
May it
Whoever, represented.
please the court.
I'm not that good at court, man, okay? So y'all, before y'all get in the comment section say, oh, BPO, I'm not a court person, bro. I would get so bored and I'll fall asleep, man. I'm not lying to y'all.
Defense and members of the jury. It was 2 a.m. and the defendant was driving down South Monroe Street with no headlights whatsoever. We learned in today's trial that it wasn't just as simple as him forgetting the lights. He didn't notice that his headlights were off for at least 5.5 miles. He didn't realize. And when he was finally stopped by law enforcement, his words tell us all that we needed to know from the start. Of course I've been at the club, had a couple of drinks. I've been at that club. I've been at Pockets, Pool, and Bar. His words are all we need.
The statement of law.
Now I want to pause for a moment.
The statement of law.
Sustained.
I want to pause for a moment and thank you.
Just
Because-
hold on a second, Ms. Hershey. The state has just misstated the law for what is needed for driving under the influence. Please use the jury instructions that I presented to you as your instructions on the law. You may proceed.
I wanted to pause for a moment and just say thank you to everyone for being here. I know we spent Tuesday all together going through jury selection and deciding who would be a best fit for our jury. And throughout this process, you've all been great. We went through Friday, and of course there were some delays, and of course you also had to take time out of your day to day, which was not expected. And to say the least, we couldn't have gotten through this process without you. So I commend you all for that, and I'm beyond grateful for that. So what I wanted to talk about is what the law is in this case and what we have to look to see whether or not the state has met its burden. As the judge just instructed us, the defendant in this case, he's charged with driving under the influence. Now, driving under the influence has two individual elements that the state had to prove to you here today. First, the judge told us that the first element that the state needed to prove is that the defendant drove or he was in actual physical control of a vehicle. Now, members of the jury, I don't think this is something that's in dispute in this case. We've seen the body-worn camera. We've seen testimony from two officers who told us here today that when they first encountered the defendant, he was driving his vehicle down South Monroe Street. The body-worn camera footage that we saw on the televisions that are in front of you showed the defendant inside his white Mercedes when law enforcement approached him. They showed him in the driver's side seat behind the steering wheel, and he was the only person in that vehicle. So when we look at the evidence and the facts in this case, we know that the state has in fact established the first element, that he was driving a motor vehicle. So that brings us to the second element. And this is the second element that you really are here today to decide. See, as the judge just told us, while driving or the state must prove that while driving or in actual physical control of the vehicle, Calvin Riley, the defendant, was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. Now that element is a bit lengthy, so I want to break it down into two separate parts, starting with under the influence of alcoholic beverages. We learned throughout today's trial that the defendant was undoubtedly under the influence of alcohol. There was multiple things that we learned that through. We learned that through his own admissions. When Officer Muth approached the vehicle...
Objection, please statement that.
Let's go sidebar.
And then they're gonna sit there and discuss it. So this is what I mean, bro. This shit, I will fall asleep in court. They kick me out.
State your statement.
So, as I was previously stating, the first element, or the first part of this second element that we have to prove is that the defendant was under the influence of alcoholic beverages. Now, when we look to the facts and the evidence in this case, we know that there's several signs or several statements from the defendant that point us to the conclusion that he was under the influence that night. For starters, he admitted to Officer Muth at the scene that he had had a couple of drinks that night. He told Officer Muth that he was at a bar that night, that he was out at a club. How do we know he was out at the club? Well, we saw the wristband on his wrist that corroborated that statement. We know he was out drinking that night. We know that he was out there, and he left around the time that bars close. It was 2 a.m. So when we look at that element, we would assert that it's been proven. And if that's not enough, we can also look to other things. We can also consider whether or not his normal faculties were impaired. And that's the second part of element 2. As the judge just instructed us, normal faculties include multiple things. It includes our ability to see. So when we're talking about the defendant's ability to see that night, there's several things that officers noted that were concerning. So let's talk through those.
So basically what the state is trying to say that this dude's an an alcoholic, not alcoholic, maybe, but it's basically trying to imply that he was drinking at the club and he ordered the bar and that he, he was driving drunk. And that's why I was saying that when he told the officers that he had a couple beers, you don't have to tell them anything. Like, and it kind of concerns me. I don't understand why he just didn't do the. I just don't understand like why he just didn't do like the blood test, because I think he refused it. And I feel like if he was really under the influence, that would have just killed this whole case and completely, and he would have been good. But since he didn't do the blood test and all that, it's like they basically have to apply that little, he's doing this and that, and just she just basically saying like it's pretty obvious that he was drinking here and doing this and that he was driving under the influence. But they're not mentioning about the bottle. See, that's what they're not trying to like mention at all, is about like the evidence, because that's what the his attorneys and them were trying to tell the officers, like, did y'all use that for evidence? And they never said it. They just said that it was like I guess an add-on, or not add-on, but just adds on to the suspicion.
Starting with Officer Oliver. Officer Oliver told us here today that when she first saw the defendant, he was driving down the road in his white Mercedes. And as he was driving down the road, he didn't have his headlights on. Like I mentioned earlier, he was driving nearly 5.5 miles with no headlights, and he couldn't see that. It's dark outside, it's 2 a.m., and you can't tell that you're driving down in the road in the dark? What does common sense and reason tell us? See, when we look at the jury instructions, we see that when somebody's normal faculties are impaired, it means that impairment means that those normal faculties are diminished in some material respect. And when you can't even tell that your headlights are off, I think it's safe to say that your ability to see has been diminished. And if that's not enough, there's another part that we should talk about. Because when Officer Oliver tried to tell the defendant about his headlights being off, he didn't believe her. He asked her, "Are you sure about that?" I believe those were his words. "Are you sure about that?" It took Officer Oliver debating with the defendant about having his headlights off that she finally had to reach inside his vehicle and show him the turning knob to turn them on. He still didn't believe her until she finally clicked the knob to the right and showed him that they were off. And it wasn't until the lights on his headlights finally illuminated that he finally widened his eyes and then turned to Officer Oliver and still questioned her judgment and her ability to see that his headlights were, in fact, off. It's not reasonable. And the reason that we know that his sight was impaired was because of his admissions to drinking alcohol that night. So that brings us to another normal faculty that I wanted to discuss with you. We listened to the defendant talk about, or one of the additional normal faculties that we should consider during deliberations is the defendant's ability to talk that night. Now, don't get me wrong here. The video was sometimes a little hard to hear, but then other times we know he was clear. He was shouting, he was yelling. Those times it was crystal clear. And when we watched those videos here in court today, it was clear that there were times that he was slurring his words. He was not making sense. For example, when Officer Oliver stopped him in his vehicle, he said, "Why you slow me down?" Is that a statement that makes sense? No. But that was what was running through his head at that time. Why you slow me down? So we have to look at his speech in the...
I mean, I ain't gonna cap on that. I have heard a lot of people actually say that. Like, when you get stopped, like, why'd you slow me down? Like, and some people actually mean, like, why you stopped me? It's not... She just trying to make it seem like he drunk out his mind. And I'm not trying to say that I condone any drinking and driving. You drinking and driving, like, you gotta go to... Like, that's wrong, regardless. But she trying to make it seem like he's, like, plastered out. Like, he was, like, falling and stuff. When I have heard people use that term before.
Those moments
and whether or not we think based on his speech that it was diminished in some material respect. So let's talk about another one now. The defendant's ability to judge distances. Members of the jury, this is a big one. And I encourage you to remember the demonstrative that I showed during the testimony of Officer Muth. So I want to turn that on for you guys. This is a map of the defendant's route that night.
And it sadly doesn't show because if you ever did jury duty, I have before, it only shows the juror, it doesn't show anybody else. But I think she's showing like the map of the location that they was at in Tallahassee, in the town that they was at.
Based on his own admissions. Like I originally stated, when he was first stopped by Officer Oliver, first he says, "Oh, I'm just going home, I'm going to West Brevard Street." Well, that didn't make sense. Because as Officer Oliver told us on the stand on Friday, he was heading the opposite direction. So are you really going home if you're going completely the opposite direction? I think not. So now let's look at the other perspective. Because after Officer Oliver gets to the scene, Officer Muth, as she told us, went and did her own independent investigation. She told us here today that she went up to the defendant and asked him, "Where are you going? Where were you planning on going?" He said he was going home. And when she asked, "Where are you coming from?" she said, he said, "I was coming from Puckett's." And as we learned in today's trial, Puckett's is a local bar here in Tallahassee located on the north side. So when you look at that map that we showed you during today's trial, you can see that the route just doesn't make sense and his ability to judge distances was materially diminished. Right on before law enforcement stopped him that night. It's not clear, but it clearly was on. And that's finally where they stopped him, and who knows how much further he would have gone before law enforcement stopped him that night. It's not clear, but it clearly wasn't in the direction of his home, because if he was heading home, he would have to turn all the way around and go the exact same way north back to his address. So, members of the jury, when we're talking about the defendant's ability to judge distances, we know that his ability to do so was diminished in some material respect. Absolutely. The jury instructions also say that normal faculties include your ability to drive an automobile. That's another thing that we heard about in today's trial. Not only the lack of headlights, but also Officer Oliver told us about his driving pattern when she went to stop him. He was speeding down South Monroe Street. At least 10 miles. Who knows, maybe potentially more. We don't know because Officer Oliver didn't have a speed gun to tell us exactly how far. But based on her training and experience, she was able to assess that he was speeding that night. Now, he wasn't just speeding. He was speeding past 2 police cars, with one of them that at least had their headlights on. Does that make sense? To drive over the speed limit as he's passing a police car Are not credible.
I ain't gonna lie, hers a little too long, man. I'm gonna go and skip to his attorney now, but y'all basically get what she's trying to tell the jury though, as far as, you know, he's too young, and you know, so let's go on with his attorney now.
Calvin Riley is innocent. You have every reason to question every single thing these officers testified about. They are not credible. Officer Oliver lied to you under oath, and she lied over and over from the second she pulled Mr. Riley
Objection,
over.
inflammatory, and misstatement of the law.
Over and over from the second she pulled Mr. Riley over until the second she got off that witness stand. Officer Muth lied to you about what she placed Mr. Riley under arrest for. And she lied to her sergeant about what she found in the car. These officers are making things up. These officers are laughing. These officers are asking each other if their cameras are on. These officers are turning off their cameras. These officers are taking an oath to swear to tell the truth, and then these officers are lying. They did it right there in front of you. When you apply the law Judge Jones instructs you on, with the conflicts in the evidence and the complete lack of evidence, you have seen over these 2 days, it is clear. Calvin Riley is not guilty. Officer Oliver opened a bottle of vodka, a bottle that had never been opened before. You hear her break the seal, pour it out, and then put it back in the car. Then she used that evidence against him. She and Officer Muth told their sergeant they found a bunch of alcohol stashed in his car, and that the bottle was open. This is simply not true. There is nothing in that cup, which if you watch the video closely, has a lid on it, and the vodka bottle that was opened by Oliver. Members of the jury, these officers want you to believe that they only turned off their cameras because they weren't investigating anymore. Yes, they were. The sergeant on scene asks if they're live. Officer Muth asks if they're live. Oliver shakes her head no. Sergeant turns his off and Muth turns hers off. They are all still investigating. Your jury instructions tell you that you all get to decide what is reliable. Nothing that these officers testify to is reliable. Let's start from the very beginning. Oliver and Muth are at a completely different traffic stop. Oliver says she notices Mr. Riley's car going by without headlights and at a high rate of speed. She doesn't have a radar gun. That's just her word, which we know is not believable. She tells you that he was swerving. None of that is captured on her camera. There is no camera footage of it. It's just her word, which we knew.
Which is weird because doesn't most police cars, they have dash cams? So because I low-key wanted to see that too, to see if he was actually swerving, and they didn't have that. They didn't have that video of that. Everything didn't get started recording until they turned their body cam on.
Is not believable. She tells you that she noticed his eyes were glossy through his glasses. And on Friday, for the first time, she adds that they're bloodshot. She's been under oath twice before, as well as written a statement that was also under oath. And none of those 3 times did she ever say they were bloodshot. The first time was on Friday. Members of the jury, you can see Mr. Riley's eyes on camera. At one point, he leans into Officer Muth's body camera. His eyes are not glossy. His eyes are not bloodshot. Again, her word is not believable. She tells you that she smelled an odor of alcohol. But in her camera footage, the first thing she tells Officer Muth is that she can't really smell anything. She tells you that she smelled marijuana. Again, after telling Muth that she can't really smell anything. And there is no marijuana, paraphernalia, or anything regarding it, nothing found in the car. And let me take a moment to point to something out here, because the state is making a huge deal about Mr. Riley yelling. The officers call him belligerent and irate. Members of the jury, he's completely cooperative and polite up until she says she smells marijuana. That's when it all changes. At that point, he knows exactly what they're trying to do. And yes, he is absolutely upset. And he was very right to be. He's being falsely accused for something, and he is mad about it. He's completely justified in acting the way he did. And also remember how he interacts with Muth at first, cooperative with turning off the car, cooperative with taking the keys out, cooperative with getting out of the car. Remember how he interacts with Sergeant Smith. Completely cooperative and respectful. It is only when Officer Oliver says that she smells marijuana, after saying she couldn't smell anything, that he gets upset. And it is completely understandable. So now Muth gets on scene. Oliver asks her to verify Mr. Riley's address as 429 West Brevard Street. But when asked, Mr. Riley said it was a family house. He never said that that was his residence. That was something that Officer Muth just assumed. And remember, at this point, it's 2 officers there with Mr. Riley. Oliver wants Muth to see if she thinks this is a DUI, and is excited to watch her conduct an investigation. Officer Oliver promises that she'll do the next one. The state wants you to believe that the evidence tampering and the lying about it doesn't matter, because he was already under arrest for DUI. But that is not true. When they order him out of the car, which he does cooperatively, they arrest him, handcuff him, and tell him it's because his license is suspended. And again, when they're...
And that is actually true, because when they did put him in handcuffs, they did say, because your license is suspended, we're going to put you in handcuffs. They didn't mention about the DWI or alcohol or anything. They didn't mention, only thing they actually mentioned was weed. And yeah, he did turn up. When they mentioned that weed, he turned up like really quickly, because he knew that they were lying just to search his car.
They're searching his car, they indicate that they're going to charge him with driving while license suspended. They say DWLSR, which means driving while license suspended or revoked. They are telling him that he was only under arrest for a suspended driver's license. But now they want you to believe that he was under arrest for DUI. Their testimony was that he should have inferred that he was under arrest for DUI. But members of the jury, the law does not allow you to make inferences. That is reasonable doubt. The very first time that anyone tells him that he is under arrest for DUI is when they're taking him to jail. That is the first time they tell him that. And that is after they've already searched his car and used that bottle of alcohol as evidence against him. And this is also very important distinction, members of the jury. Remember, at this point, all the police need is probable cause to arrest someone. That's a very low standard versus what you must today, here in the trial. When a man's liberty is at stake, the law is clear. The state must convince you of every element beyond and to the exclusion of every single reasonable doubt. And there is overwhelming doubt in this case. Now, Mr. Riley is in the back of the police car. He is under arrest. And again, at this point, he is justifiably and understandably upset. But members of the jury, listen to him. Listen to his speech and his articulation and his communication with the officers. He is not slurred. He is not confused. He is just mad that he is being falsely accused.
And then after her, because it went on for a minute, and then the state came back, basically, like I said, the same thing, trying to convince the jury
On this
that, you know, he... How'd you call it?
liquor bottle that was found in the focus on this entirety of this trial. In fact, majority of their closing argument focused on this sealed liquor bottle that was found in the defendant's vehicle. I didn't want to mention that during my initial closing argument because, as I briefly stated, it's not evidence during this trial. It's just not. See, members of the jury, the defense is saying the words that law enforcement manufactured evidence. Does opening a bottle of vodka sound like manufacturing evidence? Does it sound like this law enforcement officer went to the store and bought a bottle of alcohol just to put it in his vehicle? No. You've seen the video in this case. You've seen the body-worn camera footage that shows us that when they searched the vehicle, it was already in the defendant's car. Officer Oliver never once went to Officer Muth or Sergeant Smith and said, hey, I found an open bottle of liquor. She didn't. And what that
But yes, she said that it was open. But after that argument, they went on for like, I ain't gonna lie, I pushed this video a little bit longer than what I should have. I think I might break this up, or I might post a full thing and then just break clips of it so it don't bore you. But basically, after like damn near an hour, they came with a verdict right here.
Madam Clerk, please publish.
In the matter of the State of Florida versus Calvin Riley, case number 2023-CT-854, we, the jury, finds as follows as to count one of the information, driving under the influence. The defendant, Calvin Riley, is guilty. So say we all this 8th day of April 2024.
You may be seated. Does either side wish to have the jury polled? State?
No, Your Honor.
Defense?
Yes, Your Honor.
All right. Madam Clerk, can you please poll the jurors?
Juror number 1, is this your verdict?
Yes.
Juror number 2, is this your verdict?
Yes.
Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict?
Yes.
Juror number 5, is this your verdict?
Yes.
Juror number 6, is this your verdict?
Yes.
So, ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you on some very special privileges enjoyed by jurors. No juror can ever be required.
So he was found guilty of it, and I think he got sentenced.
To talk about this. It will be up to you to decide whether to preserve.
This is where they talk about his sentencing, what he's gonna get.
And you may be seated.
We're gonna talk about it.
On this jury, you are excused.
Can I just have a moment? Required mandatory minimums under.
Okay.
So this is what
The
they
state
talk
would be
about.
asking for 12 months probation with, as a special condition, 10 days jail, in addition to other required mandatory minimums under the DUI statute.
So that's the DUI. Are there any prior DUIs?
No, Your Honor.
Okay, so DUI level 1, the 50 hours of community service, 10-day vehicle impound, the 6-month DL suspension. I don't have a standard plea form in front of me. Do you remember what the other standard DUI firsts are?
Yes, Your Honor, 50 hours community service.
The victim awareness panel.
And I believe a $500 fine.
Relevant criminal history.
Your Honor, he was previously convicted for 2 felony batteries.
The offer from the state tried to adjudicate guilty to the lesser offense of Nevada driver's license, lesser offense of reckless driving, and adjudicate guilty to the lesser offense of Nevada driver's license with no probation, no conditions. Already, by taking the minimum, adjudicate guilty to DUI with the minimum per statute, it's already a trial task. The state is now asking for much higher. At this point, it seems vindictive based on the publicity. So we would be asking for adjudicate guilty DUI with just no minimum conditions.
All right. Thank you. Any response?
Yes, Your Honor, and on top of that, we would just like to also add the cost of prosecution. In response to that, as Ms. Goodfellow is aware, this case is, like when the original plea offer was extended, I had not yet quite looked into the entirety of the facts of the case. I was relying on the defense's word alone at that point, and I was having a good faith basis to believe that But my concern at this point is we've gone through this entire process. We've perpetuated testimony of a pregnant officer who is actively having labor pains. And then additionally, we've also come to trial with additional facts and evidence that were not discovered a month ago when that plea offer was made. So given the facts and the evidence of this case, he's not willing to accept responsibility for his actions and the consequences that they can bring. And that's why the state is basing our request for this specific sentence.
Mr. Riley, please rise. Do you have anything that you wish to say before I pass sentence?
I accept the responsibility for getting upset and let my emotions get over my judgment of just being a person and staying calm. Like I stated before, I was only going through this emotional stuff because the past I've been through with law enforcement and what I started going through that night with these officers, it was just a repeat of what I experienced growing up here. And it made me very upset and angry. And if anyone was hurt in that moment, I apologize, but at the same time, I was hurt too. And I'm still dealing with it. And that police that the state is talking about, I was unaware of that until like they came on board and I had a new lawyer. All this stuff was brought to my attention sweat last month and things started changing. But I don't have time to process all this stuff neither. I don't know what else to say.
Okay. Thank you. You didn't have to say anything, but I appreciate you speaking. All right, I'm going to adjudicate you guilty as I did before, sentence you to 6 months probation. As a condition of that probation, you'll do 10 days in the Leon County Jail. You'll also have to attend and complete DUI level 1 school and any counseling as recommended. 50 hours of community service. Your vehicle, if you own one, will be impounded for a period of 10 days. If you no longer own a vehicle, you just need to get a certification from the DHSMV saying that you no longer own the vehicle, and that can be waived. Your driver's license will be suspended for a period of 6 months. You'll need to attend and complete a victim awareness program. You will have alcohol conditions with random breath test once per month. And your probation can terminate early at the halfway point if you have completed all of your conditions. And Madam Clerk, if you could please announce the standard fines and court costs, and would the defense like them to be itemized?
So yeah, he got found guilty. He has 10 days in jail and 6 months probation, license suspended. That's kind of weird with the car thing, considering that this was over a year ago. I didn't even think they would. I mean, I guess, but I've seen a lot of people say that they feel like race played a factor in this, and I've never been a type to use a race card or anything, but I'm not saying that I feel like race was a factor. I just definitely feel like him talking shit definitely made them not want to work with him at all. But as far as the sentencing goes, what do y'all think? Do y'all think that the sentencing was fair, or do you think like the system failed us again? Like I said, I really felt like he shouldn't have told him where he was coming from, because you don't have to tell him anything. But it's also weird that they didn't even get a blood test, because a blood test would have killed all this. But I guess since he refused to do it, or maybe he did, I don't know if he refused. I know he refused to do the test as far as on the road and the breath sample. But if it's true, if he only had like 1 or 2 beers, I mean, no one's not gonna get drunk off that, and that usually, people be fine. But I don't know, man. How the state was coming, they were trying to make it seem like this dude was like an alcoholic and he was swerving. There was no video of him driving as far as to even prove that fact. This is all really just off all words and just putting a scene together, because how the state was trying to put it is that he left the bar too and then this and that, so he had to have a lot of drinks. They were trying to paint that narrative. His attorneys and them were trying to paint like, well, they dumped out the liquor bottle and they try to use that as evidence. So it's really, this is a real mess, man. It's just, everything is just off words. Like nothing, there's no proven fact. The bottle was clearly closed. There's no breathalyzer test, no blood test, nothing. This is all off words. So this is what the jury decided. And I mean, it took the jury like, damn. I believe it took the jury like almost an hour before they came up, or 50 minutes or so, 51 minutes. And then they came up, so they were really like talking about it. And I don't know, man. I was really hoping he was gonna get not guilty, because the cop was clearly lying about that. But I really want to know what Officer Oliver's track record is, if she ever did this before, or anybody else she ever arrested, because this, just for her pouring that out and unsealing it just to like kind of get some evidence, is just really grimy to me, like, because she knew it was closed, and they never poured out his cup that he had in there. So I don't know, man. Y'all, like I said, y'all let me know what y'all think about this whole verdict, this whole trial and everything. I'm really sorry for this pushing over an hour. I was really trying to minimize it. Like I said, this whole entire thing is like 6 hours, so I'll link the video in the description. Y'all want to see it. I also might chop up some clips and then post it out there too, so y'all can see different, everybody's different statements and everything that happened at court. This is just like the longer version of it, if y'all just don't want to see them small clips. So. And like I said, I really do appreciate the love y'all been giving, all the like and supports. Like I said, y'all new to the channel, man. Please subscribe, like, and all that stuff, man. I really appreciate y'all. And like I said, just let me know what y'all think about the state of Florida versus Calvin Riley. Do y'all believe that he was guilty? Y'all believe that he was not guilty? And y'all have a wonderful day, and I'll catch y'all again in the next video.